Blake Lively communicated with herself in court through her shell corporation, and the lawyers for her shell company were corresponding with her own legal team, effectively making Blake interact with herself through legal filings while pretending they were separate entities. Blake Lively is concealing herself behind a corporate veil known as Van Zandt Inc., a business that initiated legal action in September 2024 against no identified party in New York State, specifically the Supreme Court of New York County. As part of this lawsuit, she issued a subpoena to Stephanie Jones and Jones Works, seeking complete records and information from Jen Abel's phone. Throughout this process, no notices were given, no documents were shared, and the case itself made little logical sense. It bore zero connection to sexual harassment, and Jen Abel had no known affiliation with Van Zandt Inc. Currently, Jen is attempting to obtain a copy of the subpoena, along with the corresponding records she had provided to Jones Works, including communications with Jones Works and details related to the company. Now we understand the reason behind Blake Lively initiating the protective order in this matter and why she imposed such strict limitations on filing and obtaining discovery. It now seems that Blake Lively is engaging in courtroom manipulation, using legal maneuvering, with her legal team participating in these tactics. The protective order contains a confidentiality provision, which requires anyone handling confidential information to sign a non-disclosure agreement. Once signed, the individual cannot disclose that they signed it. They are forbidden from sharing it and may only utilize it within the current action under which the discovery was filed. Blake taunted Jennifer Abel by submitting legal documents that stated, "We already gave you a copy of the discovery. It exists under another action unrelated to you. There is a subpoena located there, but some of it is marked confidential. And despite it being in your possession, you are barred from using it." So when Jen went to court to compel access, her team told the judge, "This shell company belongs to her. We need this data. We are entitled to it." This was the mechanism used to obtain the discovery. Blake's attorneys have confessed to using this litigation strategy to retrieve the discovery. Interestingly, the lawyers who initially represented Van Zandt have now been replaced, with Van Zandt bringing in outside counsel separate from Manet, suggesting something questionable occurred. Why would Van Zandt abruptly require a new attorney? Van Zandt was previously represented by the same law firm that now represents Blake, and they are now pretending to be entirely disconnected from this legal action. Watching this unfold in court is almost villainous, even sadistic in nature. I genuinely do not envy those who are the target of this legal conduct. It is abusive. If Judge Lyman even momentarily believes this strategy, I will lose all confidence in him. Any faith in achieving justice in this courtroom will vanish. This is the most blatant misuse of the court system I have ever witnessed. It is abusive precisely because it seeks to obscure true identities. Blake is saying, "Here is the evidence," while her company simultaneously says, "You are not permitted to have it." Here's the document they submitted. They are treating Jen Abel as if she's unintelligent. They accuse her and Wayfair of using these proceedings for publicity purposes, an excuse that has long been worn out. The motion appears to be yet another move by Abel and Wayfair to manipulate the judicial process into continuing a harmful media narrative aimed at Blake Lively and her affiliates. This time, by requesting records from a third party, information Abel already has, or which has no relevance to the case's claims or counterclaims. Van Zandt does not explain to the court why this lawsuit was initiated, nor do they provide any reasoning for filing it, while Abel presents no legal or factual basis for her argument, simply because none exists. Moreover, Abel tries to mislead the court by implying that two subsets of documents she is requesting, the subpoena issued by Van Zandt and the associated records produced, are not currently in her possession, even though she knows very well that they are. This is stated in a letter from counsel representing Ms. Lively. In essence, this is Blake, Lively referring to herself while simultaneously portraying Van Zandt as being uncooperative. But in reality, it was Ms. Abel who abandoned the meet and confer process, choosing instead to file a motion out of nowhere following a 3-week silence. Suddenly, she's once again painting herself as the victim. The motion should be rejected on two central grounds. First, Abel has already obtained the only potentially significant documents: the foundational materials produced in response to the subpoena. Second, the rest of the requests either lack relevance to any claims or counterclaims, or are moot, or they should be obtained from other parties. That said, in an effort to move this litigation forward and lessen the strain on the court brought on by Abel's needless filings and her desertion of the meet and confer process, Van Zandt voluntarily agrees to turn over documents responsive to items 10 and 11, despite the fact that Abel already has them. They also agree to respond to items 1 and 4, based on the narrowed versions presented in her motion, as outlined below. The motion should therefore be dismissed as moot in regards to requests 1, 4, 10, and 11. As for request 9, which demands communications between Van Zandt and its legal team and Stephanie Jones or Jones Works and/or their counsel relating to the lawsuit, Abel should get these records directly from Ms. Jones before dragging third-party Van Zandt into the matter. This same point was used previously in relation to 2 employees from TAG, and the argument was that the information could simply be obtained from them. If the judge does not issue a consistent ruling here, I'll lose all faith in Judge Lyman. Importantly, Abel's motion is notable for what it fails to disclose, specifically, her decision to abandon the meet and confer process. Van Zandt emphasized its various objections to the subpoena, yet still offered a compromise in order to avoid court involvement. They proposed providing 2 of the items now being requested: the subpoena sent to Stephanie Jones in the New York case, and the documents produced by Jones in response. Van Zandt confirmed this offer in an email dated May 30th and extended a willingness to continue discussing the matter. However, Van Zandt's counsel received no reply, even though by then Abel had already obtained the subpoena and related documents more than a week earlier. 3 weeks later, she filed this motion with no warning, concealing the fact that she already had the materials she was asking for. The issue here is that she didn't truly possess the records due to a protective order placed on them. Abel's motion should be thrown out because she fails to show how the records have any connection to the claims or counterclaims in this litigation. She needs to demonstrate that this shell company status is true. She needs solid proof for the court. Abel proposes a far-fetched theory that these documents relate to her updated counterclaims, which are currently under review in a motion to dismiss. As I've said before, this delay tactic is clearly meant to let a biased judge, one who has already shown partiality, toss out the case entirely and ignore what Jen has endured. They firmly believe that they've already secured victory in this courtroom and clearly think this judge is in their corner. If they simply wait out the timeline, nobody will ever need to uncover the existence of the Van Zandt lawsuit. And if that happens, the concerns raised by this motion would disappear entirely. So Abel is reminding the court, essentially inserting herself to say, you should throw out Abel's case against Jones Works. Abel's counterclaims boil down to a workplace dispute involving her former employer, Ms. Jones, and are entirely unrelated to Van Zandt. So if Jen Abel's phone and the data on that device have no relevance to Van Zandt, then why does Van Zandt have that very phone's data? It's leading me to suspect that this entire scenario was manufactured deliberately. It's as if Blake filed a lawsuit targeting Wayfair, while at the same time Stephanie initiated legal action against Jen and Melissa, all to give the appearance that this side is at fault. That kind of structure allows the court to believe Wayfair are the bad actors, creating a facade in which they seem guilty, even though, based on the actual circumstances, it's those 2 who committed the wrongdoing against Wayfair. That's why I believe it's orchestrated, a coordinated effort. If Van Zandt had no connection to Jen Abel, then Jen's previous employer would not be in possession of her phone. And yet again, this shows how Blake refuses to take responsibility for the fact that Stephanie may have stolen that data. Instead, she is positioning Stephanie Jones as the sole person to blame. The claims in question stem from incidents surrounding Abel's termination, when her phone was accessed by her former employer in August 2024. Situations in which Van Zandt is never claimed to be involved at all. These events happened weeks prior to the Van Zandt-initiated legal filing. So how would Van Zandt have known about the phone, or that Stephanie Jones was the person to approach to obtain it, if they supposedly had no awareness of the situation? Furthermore, the request targets documents that are more appropriately acquired from Plaintiff Jones or others connected to the case. and Jen has already informed the court that they are unwilling to provide them. Van Zandt is not a named party in any of the litigation involving Ms. Lively and the Wayfair parties. Blake Lively is utilizing the materials gathered via Van Zandt's subpoena, while Van Zandt has the nerve to tell the court they aren't connected to any lawsuit. Meanwhile, Blake's legal representative admitted that it's fairly common to use a company to obscure your identity. So Blake is essentially claiming she's not directly involved, just exploiting a legal loophole. It's a tactic designed to exploit the system, and everyone knows that Van Zandt is simply Blake in disguise. Abel has already received the subpoena and the documents from Ms. Lively, who is herself a party to the related proceedings. Any communication that involves Ms. Jones, if it exists, should be sought through the document requests Abel already sent to Jones, although Jones will undoubtedly refuse to hand them over. In the end, this motion is just another move in the consistent pattern of behavior shown by Abel and her legal team, misusing the court system to push a narrative aimed at influencing media perception. There's no legitimate legal need for Abel to pursue this discovery. If PR weren't the goal, she would have kept communicating through the meet and confer process, or at the very least replied to Van Zandt's May 30th message, and told the court she already had the documents she's supposedly requesting. If she insists that she needs a second set of the same materials to verify what's already in her possession, then fine. Van Zandt is willing to reproduce those items just as they previously offered. Furthermore, to help resolve the disagreement without adding more to the court's workload, Van Zandt will also turn over its articles of incorporation, which are public documents, along with written consents from Van Zandt's board of directors, showing who the officers and shareholders are, fulfilling requests 1 and 4. Now, as for request 9, any communications that are responsive and involve Jones and Jones Works, assuming such messages exist, would be in Ms. Jones's possession. And they're asking the judge to throw this out as moot. The letter they filed is beyond abusive. It even includes a copy of the email correspondence exchanged previously. In the May 30th email, during the meet and confer effort, Van Zandt reminded Abel's counsel that they weren't sure if she had already received any part of the subpoena and resulting documents due to the protective order in the Lively litigation. Abel offered to review the protective order to see what details could be shared regarding her receipt of those materials so that she could confirm whether she did, in fact, have the subpoena and the associated records. Naturally, Van Zandt stated they'd be happy to reach a confidentiality agreement, including abiding by the protective order's exact terms and conditions. What Van Zandt was essentially demanding was a confirmation that Abel would reveal whether she possessed the discovery in question. But Abel responded that due to the protective order, she was unsure. First of all, not everyone has access to the full discovery. Only select attorneys can view it. And if some of the content is marked confidential, it can't be brought into Jen's separate lawsuit. Even if the documents were sent to Wayfair, once any pages are stamped confidential, they're not legally allowed to be introduced into Jen's case. So despite the fact that the discovery reached Wayfair, if Blake labeled any of it confidential, which she did, then it's automatically restricted from being shared across legal proceedings. Now Van Zandt is trying to make Wayfair break that protective order by demanding to know exactly what discovery they received, which would constitute a direct violation, possibly amounting to contempt of court. And yes, the protective order specifically states that disclosing protected information to unauthorized parties can result in contempt. The judge involved has already indicated he'd have no hesitation in pursuing contempt charges if it came to that. Then, within their formal objections to the subpoena, included as attachments, they attempt to frame this entire lawsuit as completely valid. Afterward, they divert blame and tell Jennifer Abel that the sole reason she's pursuing this is to shift attention from her alleged wrongdoing against Blake. The majority of the documents Abel is trying to obtain are entirely irrelevant to this case. And for the records she's asking for, like those, connected to the subpoena and what was produced, she already either has them or can gain access through other, less burdensome means, such as discovery requests aimed at other parties involved in this litigation or related cases. It's actually quite disturbing, borderline malicious, for them to suggest that Jen already has full access to her own communications, especially considering her phone was stolen. So this subpoena looks like nothing more than a smokescreen, an attempt to steer focus away from what really happened. They're trying to argue that her messages actually prove she orchestrated and enabled a campaign to defame Blake Lively, casting her in a false light, all in revenge for speaking up about sexual harassment on a film set. I've personally viewed a lot of the internal communications Jen was referring to, and I didn't see her organizing any kind of smear campaign or spreading false narratives. What I did see was her offering emotional support to Justin, constantly encouraging him, keeping his spirits up, helping him navigate everything, and motivating him to keep moving forward. She kept reminding him that although things were difficult, he had to push through. I never witnessed her planting media stories or manipulating the press. Aside from referring to Blake using the C word, and I'm not even sure whether it was Jen or Melissa who actually said that. I didn't see anything malicious. And honestly, if she did use that word, maybe Blake was acting like one. But to even begin judging that, you'd first need to acknowledge that sexual harassment took place, which they don't. Second, you'd have to believe that this so-called retaliation or media retaliation happened because Jen raised these concerns, not because she supposedly spread lies or accusations. It's also important to mention that Justin was constantly receiving threats from both Reynolds and Blake, serious threats. But instead of addressing that, they've decided to pin the entire issue on Jen, making her the villain. What's obvious here is they had already settled on this smear campaign defense well before Melissa was ever brought into the picture. It was a narrative they intended to use from the start. And then they retroactively built a case to support it. Melissa was barely on the team for a week before they began accusing her and Jen of leading this alleged campaign, proving they had their angle ready and were just looking for a way to justify it. Meanwhile, they ignore all the real-world events and actual behavior, including things Blake herself said. Stephanie is the one who accessed Jen's private phone data. Whether or not that qualifies as a crime, I don't know. Jen says it is, but either way, Stephanie then handed that private information over to Leslie. Leslie, in turn, informed Melissa and Nathan that they were about to be sued back in August. But here's the key detail. Leslie should never have seen any of that data in the first place. There was a confidentiality agreement between Stephanie Jones and Wayfair, and also between Jones and Abel. Despite this, Stephanie gave everything to Leslie, probably trying to save herself because she had previously been planting stories. Now things get even messier. Stephanie Jones is now attempting to obtain information from both Meta and Pinterest, demanding the identities behind the Stephanie Jones Leaks pages on Facebook and Pinterest. But Meta and Pinterest are pushing back. They're objecting to the subpoenas and refusing to comply. So Stephanie has now filed to compel them to disclose the names behind those accounts. According to her, 2 of Melissa Nathan's employees are allegedly the individuals operating those anonymous accounts. I have no idea whether that's true or not, but there are tons of pages out there made by people who dislike public figures. Entire channels and sites exist just to criticize individuals. And looking at what's posted, I don't know if the content is even defamatory. For example, the Pinterest profile bio says, Stephanie Jones is known to leak information about her clients to the press to save the day and win their gratitude. That might not be defamatory. It might just be a general opinion. Same goes for the Facebook tagline, which reads, Stephanie Jones serves legal letters based on trumped-up claims and uses personal and professional threats. She calls that false, but I actually got a legal letter from Stephanie that was completely baseless, made-up accusations with zero foundation. And honestly, that's not defamation if it's true. And if it's a personal opinion, it's protected speech. Not every statement needs to be prefaced with, in my opinion, to count as opinion. Some are clearly implied. Stephanie is now telling the court that Brianna Clough and Catherine Case issued vague objections to the subpoenas, which only asked for information about who created the defamatory Facebook and Pinterest accounts, and by extension, the related website, and yet the request still asked for their personal data. Now, the Facebook account only includes that single tagline. There are no other posts. Same goes for the Pinterest account. One sentence in the bio and nothing else posted. Yet because of those limited lines and the connection to the linked website, they're accusing Melissa of being the person behind the Stephanie Jones Leaks site. Costa and Case either are or have been employees of the Agency Group, a PR firm operated by Melissa Nathan, who is also a party in this underlying legal action. She has denied any knowledge regarding the creation of the profiles or websites. Before working for the agency, Case was employed at Jones Works. Attorneys for both Butler and Case declined to confirm or deny whether the two women had anything to do with those profiles or the site. And here's where Stephanie's suspicions come in. If Meta receives a subpoena asking for account details, the usual protocol is that they notify the user that a subpoena has been issued and their information might be handed over, unless the case falls into a category where notice is not required, like child exploitation cases. But for civil cases, the user usually gets a heads up. Now Stephanie is dragging Justin Baldoni into a months-long alleged conspiracy to attack and defame her and her firm, Jones Works. What's wild is that in the Business Insider article published in August 2024, the reporting claimed that dozens of sources were contacted, not just 3 or 4. These included former staffers, a few current employees, and past clients. So this wasn't some 4-person scheme. It was a larger body of people reporting their experiences. Whether Stephanie finds that unfair or not, everyone's entitled to share their experiences. And if many people report the same patterns, it becomes harder to dismiss. According to Stephanie, the group secretly schemed for months to publicly and privately smear and defame her and her company, break contracts, and steal clients and business opportunities. She claims Baldoni was worried that accusations of his toxic and misogynistic behavior on set might become public and hurt his reputation and career. But that's curious. Wasn't this originally about sexual misconduct? Suddenly the narrative is shifting. Now it's toxic and misogynistic. Interesting how the framing evolves. Then, Baldoni and Wayfair's CEO Jamie Heath supposedly turned to Abel, who at the time worked at Jones Works and had become the main contact for both the Baldoni and Wayfair accounts. Abel allegedly brought in Nathan, who works in crisis PR, against Jones's express orders. Abel and Nathan, supposedly with Heath's encouragement, then shut Jones out of all planning and tried to keep their strategies hidden. But that's not what happened. Jones was copied on every message. Abel and Nathan didn't shut her out. They were simply trying to manage a difficult PR situation. According to the suit, they plotted to take down Baldoni's co-star just to protect Baldoni. And all of it was hidden from Jones, allegedly going far beyond Abel's role at the company. It's all untrue. Stephanie is now trying to defend herself from the lawsuit Jen filed against her. She also says that Abel and Nathan worked with Business Insider journalist Katie Warren to get that August article published, the one titled, "Who's Afraid of Stephanie Jones?" We still don't know much about Melissa Nathan's full background or what her specific role is in all of this. But what we do know is that Jen Abel informed the court she first heard about the article directly from Stephanie Jones, not Melissa. The article, which was highly critical of Jones, also helped promote the defamatory website Stephanie Jones Leaks, created by the John Doe defendants. The site accused Jones of being aggressive and claimed she was dropped by high-profile clients. I personally believe those accusations are probably true. Abel is said to have helped Warren reach out to Jones's former clients to further hurt her business and sway public opinion. Abel and Nathan even celebrated the article's release, reportedly calling it a kill story. As Jen prepared to leave Jones Works, she bragged to Nathan about how much damage she was inflicting on the company. Then she allegedly schemed to ensure Baldoni and Wayfair left Jones Works to follow her to her new firm. Here's the thing. If multiple people are claiming they had issues, if clients are dropping you, and if the topic relates to public figures, public companies, and PR professionals, then that qualifies as a matter of public interest. If someone is leaking client data, behaving abusively, and doing so from a public-facing role, it's relevant to the public. Whether the story was framed as a kill story doesn't matter. What matters is whether the contents were true. And to this day, Stephanie hasn't sued Business Insider. So now, there's the motion to compel, a complex mess. Stephanie claims that both Rihanna and Katie's legal teams responded by saying they objected to the subpoenas, arguing that the requests would invade their privacy and disclose personal details. Stephanie also submitted a declaration, which I find ironically amusing, because in it she claims that she is the victim of an orchestrated smear campaign meant to destroy her reputation. It's always a bit ironic when someone in PR, someone who has likely spent years planting stories, and leveraging similar tactics, suddenly finds those same tactics turned against them. Now, she says it's unacceptable. According to her declaration, a website was created that ran long-form exposés with false allegations about her. When the original site was taken down, the exact same content allegedly reappeared on a new site called Stephanie Jones Lies, which stayed online until earlier this year. At the same time that these sites were live, multiple fake social media accounts were reportedly created. These accounts echoed the defamatory content and constantly shared links to the websites. Stephanie claims that every time one was removed, another would pop up under a new name or handle. She discusses the Facebook and Pinterest accounts in her declaration. The Facebook account bore her name and included the statement, "Stephanie Jones serves legal letters based on trumped-up claims and resorts to threats both personal and professional." She insists this is false, but as I mentioned before, I personally received a legal letter from her filled with baseless accusations, so that part might actually be true. As for the Pinterest account, its profile description read, "Stephanie Jones is known to leak information about her clients to the press so she can save the day for them and inspire their gratitude." Stephanie says that's false too. But didn't she share information about Justin Baldoni while she was acting as his publicist? And then later pass along Jen's phone data, which also contained info about her former client, Baldoni and Wayfair. So, isn't that Pinterest statement basically a reflection of what really happened? So did she actually sue Justin to make it appear as though he had wronged her, when in fact he hadn't? All just to portray herself as his victim? That's essentially what it looks like Blake is doing too. These two appear to be playing disgusting legal games. They're manipulating the judicial process. And honestly, if publicists and people connected to them are engaging in this kind of underhanded behavior, it's shameful. It's repulsive. There's nothing respectable or acceptable about it. I don't support this at all. I've had people make pages about me too. In fact, there are entire spaces online, Reddit threads included, dedicated to spreading false claims about me. I've never been able to get them taken down, even when they're blatantly defamatory. But when you operate in the public eye or work in a high-profile industry, you need thick skin. You can't lash out when people criticize you, especially if you're someone who dishes it out to others. If you're going to give it, you better be ready to take it. That being said, if your company is working with clients to intentionally ruin someone's reputation or life, especially after they stop working with you, then your conduct goes beyond questionable. It's unethical, it's unprofessional, and everything about this situation screams dishonor. That's my opinion. But in this situation, even if they did create those accounts or that site, there's still such a thing as freedom of speech. And in the United States, it's protected. So when someone says, "Stephanie Jones leaks client information to make herself look like the hero and gain their praise," that might not be defamatory if it's true or an opinion. You're allowed to criticize people, especially when it involves public interest. Now they're arguing that Brianna and Katie refused to confirm or deny whether they were the creators of the profiles and website. But refusing to confirm something isn't proof of guilt. Stephanie Jones is now also trying to link Justin Baldoni to a long-running effort to bring her down. She's claiming it was a coordinated operation, and she's making that case in her court filings. The Business Insider article from August 2024 mentioned dozens of people being contacted, not just a couple. They reached out to former and a few current employees, plus ex-clients. So this wasn't just the work of a few people. And even if the article was critical, that doesn't automatically mean it was defamatory. In fact, based on the consistency of the testimonies, it's likely that many of those accounts were true. When many people independently share similar experiences, it's harder to dismiss what's being said. Stephanie now argues that Abel and Nathan worked behind the scenes with the Business Insider reporter to plant this article as a weapon against her, that they positioned it as a kill piece, meant to wipe her out professionally and personally. But even if that was their intent, it doesn't matter unless the content was false. And if Stephanie really believed it was untrue, she could have sued the publication. She didn't. So either she's afraid she'd lose, or she knows it's true. And if what the article said was accurate, then it's protected. Again, especially when it's about a public-facing figure operating in an industry like PR. Stephanie may see herself as a victim here, but given everything laid out in court and in public reporting, she looks more like the aggressor. The evidence makes it hard to argue otherwise. Now, in the declaration she submitted, Stephanie Jones says she was the target of a malicious, coordinated smear operation meant to destroy her name and reputation. She claims the websites published detailed exposés that spread falsehoods about her, and after one site was removed, the exact same content showed up on another one called Stephanie Jones Lies, which stayed up until early this year. She goes on to say that these websites were accompanied by multiple fake social media accounts. These accounts repeated the supposed defamatory messages and constantly pushed links to the sites. She says that every time one profile was taken down, another popped up under a new identity or handle, echoing the same harmful content. One of the main examples she gave was a Facebook account using her name that included the statement, "Stephanie Jones serves legal letters based on trumped-up claims and resorts to threats both personal and professional." She insists that this is false. But as I said earlier, I personally received a legal letter from Stephanie that was based entirely on made-up accusations, things that had no basis in reality. So from my view, that statement may not be false at all. Then there's the Pinterest profile. It carried the description, "Stephanie Jones is known to leak information about her clients to the press so she can save the day and earn their gratitude." And again, she says this is false. But didn't she leak details about Justin Baldoni while still representing him? Didn't she pass along private content from Jen's phone, which included data related to Baldoni and Wayfair, after her professional relationship with them had ended? That statement might not just be opinion, it could reflect real actions. So now, the claim is that Melissa and her team set all this up, the websites, the accounts, the article, in some coordinated PR attack. But Stephanie was already under scrutiny long before that. Clients were leaving, complaints were surfacing, journalists were digging. So to say it was all a smear campaign ignores the reality that this kind of attention doesn't arise out of nowhere. If so many unrelated people are all saying similar things, especially about a public relations professional whose entire job depends on public trust, then the idea that this was manufactured just doesn't hold up. It sounds more like accountability finally catching up. And now, just because it's being discussed online and in court filings, Stephanie wants to act like she's the target of something deeply unfair. This is what happens when the tactics you've allegedly used on others start coming back your way. She may not like it, but this is the fallout of years of behavior, not a one-time attack. And even though she's trying to connect Baldoni to all of it, the broader facts suggest that this wasn't an insider conspiracy, but a wider reckoning. A moment where people who felt mistreated finally spoke up and were heard. The freedom to discuss matters of public interest, especially when it involves someone working in PR, someone managing public figures, is essential. It's not defamation when it's true. It's not harassment to tell the truth. Stephanie can call herself a victim, but the public, the press, and the courts have access to the facts now. And those facts don't paint her as the person she claims to be. Now, she's accusing others of circulating harmful falsehoods, even though all the information that surfaced about her treatment of clients, leaked data, and planted stories seems to trace right back to her own conduct. And what makes it even more troubling is how she's trying to manipulate legal tools and court processes to shut people down. Instead of confronting the facts or addressing how she handled confidential material, she's launching subpoenas left and right, trying to identify anonymous critics and silence dissent. If the criticism were baseless, if these were just wild lies, she'd have an easy defamation case. But instead of suing the media outlets that published these things or the platforms that hosted them, she's going after individual employees and parties related to the lawsuit, trying to force platforms like Meta and Pinterest to hand over private information. That's not the route. Someone takes when they have a rock-solid case. That's what someone does when they want to intimidate and scare off their opposition. Her actions now are more about control than justice. The subpoenas weren't about clearing her name. They were about finding out who was talking and trying to shut them up. She says she's being defamed, but where's the proof that what's been said about her isn't true? She insists the Pinterest and Facebook bios are false, but every example she gives seems rooted in things that actually happened. things she just doesn't want discussed. She says, Stephanie Jones serves legal letters based on trumped-up claims, but again, I've received one of those letters myself, and the claims inside it were indeed trumped up. No evidence, no legal merit, so calling it out publicly isn't slander, it's reality. And Stephanie Jones is known to leak information to the press. Well, wasn't she literally just involved in handing off Jen's data? Wasn't she in communication with Leslie, who then shared that information with Blake? So these aren't lies, they're patterns. And now she's trying to flip the script and make it look like everyone else is the problem, like she's under attack for no reason, even though the heat is coming from the fire she lit. Her legal declaration doesn't read like someone trying to defend themselves against falsehoods. It reads like someone trying to bury the truth before more people catch on. She claims people are retaliating against her for calling out misconduct. But what misconduct did she call out? Where's the documented complaint she supposedly filed before any of this happened? Because what we've seen isn't retaliation, it's consequence. Her clients were unhappy. Her coworkers were frustrated. And now those voices are being heard. If she truly believed these things were lies, she'd go after Business Insider. She hasn't, not even a threat. Why? Because everything in that article had weight. It had backing. It came from real people with real experiences, and that's hard to argue with. She can keep saying it's a conspiracy. That's her right. But when dozens of people, clients, coworkers, sources, all echo the same stories, it starts to look less like a plan to take someone down and more like a collective reckoning. Stephanie Jones may want to rewrite the narrative, but she can't undo what's already been exposed. So even if she claims all this was cooked up by Abel and Nathan, the volume of evidence and the number of people involved suggest otherwise. This wasn't some small vendetta. It was a collective outpouring of complaints from individuals who had worked with or around Stephanie. These were people who experienced her actions firsthand, people who weren't paid to say anything but were tired of staying silent. That's not a conspiracy, that's accountability. And again, if what was being said was false, Stephanie could have taken legal action against the article's publisher, against the writers, or even against those quoted in the article. She didn't. That speaks volumes. Silence in the face of public allegations often isn't strategy. Sometimes it's just guilt, or at the very least, fear that discovery will make things worse. Instead, she's turning the legal system into a weapon. She's targeting people she suspects are behind anonymous accounts. She's asking platforms to turn over user data based on nothing more than a hunch. And she's dragging unrelated parties into lawsuits, trying to uncover anything she can use to deflect blame. Blake Lively is doing the same thing. They're trying to create chaos so the truth gets lost in the noise. When Blake filed through her shell company, Vans & Inc., it wasn't just a legal strategy, it was a move to distance herself from the shady process of acquiring private data. But the connection is too clear. Van Zandt is Blake. The legal filings, the protective orders, the subpoenas, all of it traces directly back to her. They even had the nerve to tell Jen that she has the discovery already, but can't use it because it's protected under confidentiality. That's not just manipulative, it's absurd. You can't give someone evidence and then punish them for having it. But that's exactly what Blake is trying to do. She's saying, we gave you what you need, while also saying, you're not allowed to use it. It's a complete legal contradiction. And the protective order, it's being used as a shield, not to protect sensitive information, but to block accountability. By marking everything confidential, they can deny access, deny use, and even deny acknowledgement. That's not justice, it's obstruction. Now they're trying to paint Jen as someone using the court system for publicity, like she's making all this noise to get attention. But what has Jen actually done? She's filed motions, responded to subpoenas, and defended herself in court. That's not media manipulation. That's how the legal process works. If anything, it's Blake and Stephanie who are leaking stories, spinning narratives, and manipulating behind the scenes. And the whole idea that Jen has no right to the discovery because she already has it, when she legally can't use it due to confidentiality, is just one more example of how the court is being misused. If the court allows this kind of behavior, it sends a message that power and money can override justice. This isn't just a legal technicality, it's a test of fairness. If Blake and Stephanie are allowed to continue hiding behind shell companies and confidentiality stamps, then anyone with enough resources can game the system. That's the real danger here, not the fake Facebook posts or the sarcastic Pinterest bios. At the end of the day, what's happening isn't complicated. It's a case of people in power abusing that power to silence the people calling them out. And no matter how many subpoenas they file or declarations they submit, that's the story that will always rise to the surface. So now, she wants to convince the court that she's been under constant attack by a group of people who just wanted to ruin her career for no reason, while completely ignoring the real timeline of events and all the evidence that's come out. Stephanie Jones is in PR. Her job is about controlling stories, controlling narratives, and protecting reputations. But when the same tactics she allegedly used against others are aimed at her, suddenly she's crying foul. It's the hypocrisy for me. If you've built your career off leaking things to the press, throwing people under the bus, and spinning scandals to your client's advantage, then don't act shocked when the press starts telling your story too. If it's true, it's not defamatory. If it's opinion, it's protected speech. And what about Blake Lively in all of this? She's orchestrating everything from behind the curtain, letting Van Zandt take the fall while she reaps the benefits. She used the shell company to file lawsuits, collect data, and maintain distance from any legal repercussions. Then she stood back and watched as Stephanie did the dirty work, gathering info, planting stories, handling communications, all while pretending it had nothing to do with her. This kind of deception would be bad enough on its own, but in this case, it's being used to suppress evidence, manipulate discovery, and silence someone who's trying to defend herself. Jen isn't the villain here. She's the one who had her phone accessed without permission. She's the one being taunted with documents she legally can't use. She's the one being gaslit by lawyers telling her, "You already have the evidence," while also saying, "You can't submit it." The entire strategy revolves around control. Control the information, control who has access, control how it's used, and above all, control the narrative in the courtroom and in the media. That's not justice, it's PR spin wrapped in legal paperwork. Stephanie and Blake are both engaging in courtroom theatrics. Protective orders are being misused. Lawsuits are being filed not to win, but to intimidate. Subpoenas are being used not to gather facts, but to unmask critics. And the court is being flooded with motions designed not to resolve disputes, but to confuse and exhaust. This isn't just unethical, it's dangerous. Because if they get away with it, they set a precedent. They show every wealthy person with a PR problem that you can weaponize the legal system to hide the truth and punish your critics. That you can use shell companies, confidentiality clauses, and hand-picked lawyers to crush people who speak out. It's not just about Jen anymore, it's about every whistleblower, every employee who dares to question a public figure, every journalist who follows a lead. If this strategy works, if the court allows it, then anyone who speaks truth to power is at risk. But here's the thing. Truth has a way of surfacing. No matter how many protective orders you issue, or how many subpoenas you file, or how many shell corporations you hide behind, eventually the facts break through. And when they do, it's not the fake Facebook pages or Pinterest bios that look bad. It's the lies, the cover-ups, and the abuse of the system. So yes, Stephanie and Blake can keep trying to control the story. But the more they push, the more transparent their tactics become. And at some point, even the most loyal judge will have to face what's right in front of him. Don't miss the next headline. Like, subscribe, and turn on that notification bell.